held by telephone. Should I start over?
Well, maybe none of that was recorded.
Okay, let's start over. That's fine. Welcome, everyone. We're now in session for a rulemaking hearing pursuant to sections 24-4103 and 38-12-1104 2J of the Colorado Revised Statutes. I am Allison George, and I will be presiding over this rulemaking hearing in capacity as the Director of the Division of Housing. Present are the following individuals from the division: Christina Postolowski, Jessica LeHue, Margie Morris, and Cassie Vandermeer. Also present is Assistant Attorney General Tori Sampson from the Office of the Attorney General. We are holding this rulemaking hearing to adopt administrative rules drafted by division staff as a result of multiple stakeholder engagement meetings held by telephone and video conference, as well as written communications with stakeholders interested in the implementation of House Bills 11-1309, House Bill 19-1309, 20-1196, 20-1201, 21-1121, and 22-1287 concerning the Mobile Home Park Act and Oversight Program. I will consider the draft rules attached to the rulemaking notice for today's hearing, as well as written comments submitted in advance of this hearing. Any written and oral comment entered as a part of today's hearing, and any written comments submitted by 5 p.m. Mountain Time today. The proposed regulations were filed electronically with the Secretary of State on August 31st, 2022, updated on September 9th for review, and published in September 10th issue of the Colorado Register in compliance with statutory requirements. The proposed regulations were filed with the Office of Policy, Research, and Regulatory Reform on August 31st, 2022, and updated on September 9th. The Office of Policy, Research, and Regulatory Reform determined on September 27th that a cost-benefit analysis was not required for this submission since no public requests were received by its deadline. Video recordings of the division's public meetings prior to the notice of proposed rulemaking were posted on the division's website, and the recordings and slides from these meetings were shared with the program's public email list on August 16th, 2022. The proposed regulations were posted on the division's website and shared with the program's public email lists on September 12th, 2022. Additionally, pursuant to section 24-4103(3)B of the Colorado Revised Statutes, each individual requesting notification of proposed rulemaking was emailed a copy of the notice of rulemaking on September 10th. Before I move on, I would like to ask if anyone online or anyone present in the meeting would like interpretation at this time. Should we ask in Spanish?
Sure. Can you ask in Spanish if anybody needs interpretation, please?
¿Alguien aquí en esta junta está presente que necesite interpretación del inglés al español?
No.
I don't see anyone indicating that in the chat.
Okay, so at this time, we will not be doing the interpretation, or will we be recording?
We'll be recording.
Okay, so there will be a recording of this hearing in Spanish. Copies of the proposed rules, as well as the statement of basis, specific statutory authority, and purpose are available to the audience upon request. Also available on the division's website are copies of the written testimony provided for my consideration in advance of the rulemaking hearing. As part of the division's early stakeholder engagement process, comments in relation to the draft rules were requested by September 23rd. Additional comments submitted after this deadline and prior to 5 p.m. Mountain Time today, September 30th, 2022, will be received and are considered a part of the record. The division received written comments from the following individuals or entities prior to today's hearing. Both law offices, Colorado Coalition of Manufactured Homeowners, Colorado Poverty Law Project, Long Track Properties LLC, Rocky Mountain Home Association, Together Colorado, Woolhurst Owners and Manager. The written comments are available to the public on the division's website, and printed copies are available for those attending today's hearing in person. If there are any other written comments that anyone would like submitted and considered part of the record for this rulemaking hearing, please hand them to program staff at the end of the hearing or email the comments to mhpop@state.co.us. That is mhpop@state.co.us by 5 p.m. Mountain Time today, September 30th, and we will mark them as a part of the record. The purpose of this hearing is to allow interested parties and the opportunity to present comments, data, views, testimony, and arguments concerning the rules as proposed. The public is invited to testify at this hearing. All comments will be limited to 3 minutes, and I request that redundancy be kept to a minimum. Each individual offering testimony at this rulemaking hearing must be on record. Therefore, any person who wishes to speak at this hearing must record his or her name, address, phone number, and the organization represented, if any. We ask that you record this information using the paper on the sign-up sheet before you speak. The online sign-up sheet was shared over email on September 12th and September 28th. And we are putting a link to the sheet in the chat box for this Zoom meeting. If you have not done so, please register now. If you are joining by phone, you can press *6 to raise your hand, and we can unmute your line and add you to the testimony list. Is there anyone joining by phone who would like to testify but has not completed the online form?
We've got one individual, Samantha, who's raising her hand. Would you like me to unmute her so she can sign up, or just write down her name?
Samantha, can you unmute yourself and provide your name, and we'll add you to the list?
She says she's finishing the sign up online.
Oh, perfect. Thank you, Samantha. So today's virtual hearing is being recorded, and I ask that people introduce themselves prior to testifying. I also ask that you speak loudly and clearly enough to ensure that your testimony is recorded. If you are joining the hearing virtually, you are invited but not required to turn on your video while you are speaking. I will consider all the factors outlined in the Administrative Procedures Act during my deliberation of the proposed rules and the written and verbal testimony submitted in response to them. At this time, I would like to call Christina Postolowski, Program Manager for the Mobile Home Park Oversight Program, to provide some clarification and updates on the proposed regulations. Christina?
Okay. Would you like me to go?
Yes, please.
Thank you, Director George. So I wanted to say thank you to everyone who has provided ideas and feedback in this process so far. We appreciate your input and participation. I just wanted to provide some clarification on some of the proposed rules that were noticed in the register and share some changes that we're thinking about based on feedback that we've gotten. And we're open to additional feedback on the changes that I'm talking about today. So first, a couple of just clarifications on the rules that were noticed. You'll see that there are several deletions of existing rules. We're proposing deleting rules because that same language or similar language will appear in statute starting tomorrow. So that's the purpose behind the deletion of rules. A little note on timing. So House Bill 22-1287, the Mobile Home Park Resident Protection Bill, goes into effect tomorrow. The proposed rules being discussed today will likely not go into effect until November 30th, 2022. However, the legislation the rules are based on does go into effect tomorrow. So I just want to make sure that there's clarity around that. I've also recommended that Director George adopt 2 emergency rules to clarify how provisions in House Bill 22-1287 apply to mobile home parks that are currently up for sale. If adopted, these emergency rules would also go into effect tomorrow, the same day as the bill. Some clarification on rules 6.3 through 6.6. So we received several comments on the proposed rules 6.3 through 6.6, and they were rules regarding maintenance of sewer lines, park premises, roads and other pavement, and major landscaping projects. Our intent in adding these rules was not to create additional requirements for landlords. That was some of the feedback we got, was a concern around that. Instead, our intent was to inform parties of some existing mobile home park regulations under another state agency in Colorado. So most of the language in those proposed rules 6.3 through 6.6 was copied from 6 Colorado Code of Regulations 1010-12, which is a regulation from the Department of Public Health and Environment and their Division of Environmental Health. This CDPHE rule has actually been in effect in Colorado since January 1st, 1975. So just wanted to clarify that those weren't new rules that we're creating. We were trying to bring attention to some existing rules. That being said, we are going to simplify that section of our rules, or that's what we're proposing. We're going to take out what we have written for 6.3 through 6.6 and just incorporate the mobile home park rules from the Environmental Health Division by reference. And we're doing this because the Mobile Home Park Act says a landlord must maintain all common areas in compliance with applicable health and safety standards. And we feel that these CDPHE rules are applicable health and safety laws for mobile home parks. So a couple of additional changes that we're considering and we'd like feedback on. The first item is based on public feedback. We are considering adding a rule that clarifies that a new owner of a mobile home park cannot pass on the cost of remedial actions to residents. So if there was a previous complaint or enforcement action against the previous owner, the new owner cannot then pass on those costs to residents if the park is sold. We are also proposing updating the rules related to the required notice of homeowner rights, what's now actually a notice of homeowner and resident rights. So this is Rule 5. There were no changes originally proposed to Rule 5. But House Bill 22-1287 requires the division to include both homeowner rights and resident rights in that notice that we send to all landlords, and landlords then have to post and share in their communities. So we're going to clarify that landlords also need to share copies of the notice now with residents, so since it includes resident rights. And one thing in particular that this will mean is we have an existing Rule 5.4 that says if the landlord owns all the homes in the community, so there are no resident homeowners, the landlord is exempt from the posting requirement. We are going to remove Rule 5.4, remove that exemption, because the notices will need to be shared with residents. Another rule that we are considering updating, and we would like some additional feedback on, is in the proposed rules, we were proposing a way that landlords could give notice on a monthly basis of meter reading for water meters in particular. So this is for situations where a landlord would need to enter a resident's lot to read a meter to do the monthly billing. Based on feedback that we've gotten, we're considering now a rule that would allow an annual notice. So the landlord could give a meter reading notice once a year within certain parameters. So the notice would have to include a date range for that monthly reading that's going to occur. And we're proposing that that date range not be any longer than 3 days. And the notice would have to include a set time frame during those 3 days when the meter reading could take place. And that time frame wouldn't be longer than 8 hours. So for example, a landlord can give an annual notice that says, we're going to need to read your meters between the 13th and 15th of every month between the hours of 8 and 5 p.m. If the landlord was going to enter the lot on a different date or time than what they had provided in their annual notice, they would need to give residents a separate individual 48-hour notice before entering the lot. We're also proposing some changes to Rule 8.3. So Rule 8.3 is about when a landlord is changing the use of the land comprising part or all of the mobile home park, and certain homeowners are going to be displaced. So under the new legislation taking effect tomorrow, a homeowner will be able to demand compensation, relocation costs, or the value of their home from a landlord if they are being displaced by a closure of part or all of a park. We had initially proposed that a resident needed to give the landlord, or a homeowner needed to give the landlord notice 90 days before the closure was going to happen in order to, that they wanted compensation in order to get the necessary appraisals or go through other required processes and statute. In looking particularly at the appraisal side of the process, if the homeowner is requesting the in-place fair market value of their home as compensation for the displacement, we think we need to extend that time period, and we're proposing that a homeowner would have to tell the landlord they wanted compensation in the form of the fair market value of their home or the flat rate in statute 180 days before the change in use of the land would occur. And I just had 2 more comments. We know there were also several questions and comments about the provisions in 1287 around tolling the opportunity to purchase period. So this is when a mobile home park is for sale and the homeowners have an opportunity to purchase. That opportunity to purchase period is going to be 120 days starting tomorrow, again, due to House Bill 22-1287. 1287 lays out some reasons that a group of homeowners could ask for that 120-day clock to be stopped, for example, making a complaint to a non-frivolous complaint to the Division of Housing, delays outside of the homeowner's control in getting financing or necessary inspections or surveys, and the homeowners seeking to assign their opportunity to purchase to a public entity. The division is aware that there are a lot of questions about how these tolling provisions will work, how the clock will work on park sales. At this point in time, we're planning on addressing those questions through policies instead of this rulemaking. And the last note I wanted to make, just a couple of reminders. So our focus is going to be on the proposed rules themselves. So we're asking that individuals who are testifying today not make comments on legislation or bills. The Colorado General Assembly is the body that passes bills like House Bill 22-1287. So if you do have feedback on the legislation that is underlying these rules and this rulemaking today, we're recommending you contact your state legislature or legislators outside of the hearing.
Thank you, Christina. I appreciate the clarifications. So I will now call individuals to testify in order that they were listed on the sign-up sheet. Thank you, Margie. So John Victor.
Hello, everybody. Thank you for your time today. My name is John Victor. I am from GS Communities. And I wrote this before you mentioned you were considering altering some of the meter reading notices, but it's sort of to that effect. I'm in front of you today to comment specifically about the rule relating to notices for water meter readings. My sister and I own 4 parks in Colorado, and we read the water meters monthly at 2 of them. We have been doing this for years with a very narrow date range. This is a predictable, non-invasive, and brief entry onto the residence lots that has never been a source of concern or controversy. And while notice through email or phone might seem simple, I would ask that you consider our experience with trying to keep up with consistent changes in emails, swap numbers, inability to access the internet, etc. Keeping current and accurate information to each resident is nearly impossible. And that is even if folks are willing to share such information, which we really have no way to compel them to do so. As a result, under the proposed rule, to ensure that we properly give notice to our residents, our managers would have to walk the entire park 48 hours before each meter reading date and enter the lot to deliver notice that they will be reading the meters. This doubles the number of times we enter most lots per month, once for the notice and once to read the meters, which I assume seems to run contrary to what the state intends, in that they tried to minimize the frequency that management would be entering lots. This is a huge waste of both physical resources and our managers' time, especially given that we read meters on such a predictable schedule already. I have no problem with providing residents with an annual notice about water meter readings, perhaps one that we can deliver with the annual water notice. You noted in your quick update there a 3-day range. I would maybe ask for 4 days, considering there are possible 3-day weekends and stuff like that. I think that would give our managers just 1 extra day to get it done if it was a holiday after a weekend. And 8 hours within a given day, which you mentioned as well, I think is fair. Further, I would ask you consider how important it is to keep meter readings a reasonable task for managers. Knowing water usage helps people find leaks and conserve usage. It can save folks from ruining their homes. We've had numerous occasions where high usage has led us to follow up with residents to double check their houses. Water can gush out of pipes under a home, causing thousands of dollars of damages without anyone knowing. Having meters read is a helpful means by which homeowners can double check the integrity of their plumbing, saving their bank account and the environment from waste. And further, this is really nothing out of the ordinary from any homeowner, regardless of their specific home type. XL or Denver Water certainly does not deliver such notices, and I fail to see the sound justification add a burden above and beyond what is already standard for every other residence in the state. With all that being said, I strongly and respectfully urge you to consider changing the draft rule to allow for annual written notices of water meter readings. Thank you very much.
Thank you, John. Christina, any questions? Corey? No. Thank you.
Thanks.
Next is Jack Regenbogen. I think he might be on the line. I'm here on.
We're working on getting you unmuted, Jack.
Hi, can you hear me now?
We can.
Great. It won't seem to let me turn on my video. I'm happy to if I have the option.
I'm being told it won't, so my apologies for that.
Okay, I dressed up and everything. That's okay. Well, good afternoon. My name is Jack Regenbogen, and I'm an attorney with the Colorado Poverty Law Project. Thank you for developing these proposed rules and for considering our written and verbal feedback. I would like to use this opportunity to elevate 4 of our most crucial comments from our written testimony. First, we appreciate the division's proposed clarification in Rule 3.7 that park residents under a rent-to-own agreement have standing as homeowners to file complaints. This is an appropriate clarification, both legally and practically, as people in these situations are paying rent to build equity in a manner that's analogous to any other homeowner making payments on their house. However, by the same rationale, this rule should also clarify that people under this type of contract are afforded full recognition as homeowners under the MHPA. From a regulatory perspective, it just doesn't make sense to clarify standing for making complaints, but not to clarify someone's rights under that complaint process. We also urge a clarification that home ownership status apply when payment is being made to a third party, as the principle of expected home ownership is the same. Secondly, we asked the division to consider modifying proposed rules 313 and 314 to clarify that the prohibition on passing on remedial costs also applies to a buyer of a park, as Christina mentioned. We also urge the clarification that a successor is still required to address remedial orders, and that the law prohibiting rent increases from parks that are out of state compliance also apply to a successor. This clarification is direly needed to address a loophole by which a new park owner could circumvent these types of important protections. Third, it's crucial to clarify in Rule 8 that if a park has not completed a sale or a change in use by October 1st, tomorrow, the owner is responsible for notifying residents of their new legal rights and responsibilities. Beginning tomorrow, tenants will have the right to 120 days to make an offer on a park, the right to tolling under certain circumstances, and the right to compensation if they're displaced after a closure. Of course, these rights are only meaningful insofar as people are aware of them, and the proposed rules should require notice to residents as to how their rights and responsibilities have changed effective October 1st. Finally, one of the most important new protections were the changes to CRS 3812-204 that prohibit a park from raising rent if they are out of state compliance. However, the statute is otherwise silent regarding the implementation of this policy. And again, this law is only valuable insofar as it is enforceable. And so whether it be through rule or through
Jack,
other
I'm
means.
Sorry, your time's up.
Okay, I can send you the remaining feedback through email before end of business. Thanks for your consideration.
Thank you, Jack. Christina, any follow-up questions?
No questions at this time. I do have a comment for future folks on Zoom. Looks like we can promote them to a panelist for their testimony, which will let them put their video on and then demote them to participants after.
Okay,
Sorry, Jack, that we missed that for you.
thank you, Christina. Tori, any follow-up questions? No. Okay, thank you, Jack. Amy Bowe.
Hello, can you hear me and good afternoon?
Yes, thank you, Amy.
Wonderful. Thank you for once again hearing Bove Law Office's testimony and input. My name is Amy Bove. I am the owner attorney and I represent over 70 communities in the state of Colorado. Thank you for your revisions regarding Rule 6 and those regulatory obligations. It makes a lot more sense to take out the details and the requirements from the DOLA rulemaking and take that back where it belongs. Thank you for listening to our comments as well as others on that issue. I'm also happy to go after Jack. He brings up a lot of interesting points. In particular, this new proposed rule to say the new owner of a mobile home park cannot pass on the cost of remedial actions that have been ordered by the past owner. I do object to this rule because, number one, the rulemaking process is trying to hold a new entity accountable or withholding due to a past owner's possible violations. And what I also see this as being is really a workaround on the rent control ban that is in existence. Because if you do pass this rule, how does DOLA go about saying, well, your rent increase is really because of what we ordered the buyer to do back in the day? Or perhaps we didn't even order, maybe we just had a notice of violation. So we're going to subpoena your books, and you're going to need to prove to us, new owner, that your rent increase is not related to this action. And then the next step is, DOLA, what do? Do you say, okay, we can prove it now that we've been through your books, or we believe we can, therefore you can't do a rent increase? That is a direct violation of the rental ban. Now, am I advocating that somehow a seller and a buyer can get together to get around trimming their trees? Absolutely not. I am an advocate for beautiful communities, for happy tenants. But what DOLA does have is jurisdiction over that buyer, over the extensive regulations the moment they become an owner. So you can go after that buyer to fix trees. And there is a current regulation in that clearly states that can't be passed on. So this is, to me, a clear overstepping and a joining of parties that is not allowable, and also a stepping on a current Colorado statute. The next issue that Jack brought up also is that lease option individuals should have the same rights as homeowners. And Jack went a step further. He even said third parties. What does that mean practically? That means that somebody who owns a home, who is
I'm
legally—
sorry, Ms. Bove, your time is up.
We have supplied more written comments on that, but I do ask everybody to pause before adding more regulations and think about the full extent and implications. And thank you again.
Thank you, Amy, for your comments. Christina, do you have any follow-up questions?
No, I don't think so.
Tori?
No, thank you.
Okay, thank you, Amy.
Thank you.
Ben Goldberg.
Good afternoon. My name is Ben Goldberg. I am an attorney with Bove Law Offices. I am here on behalf of Bove Law Offices. And like Amy spoke earlier, we represent over 70 communities in the industry and are speaking on behalf of the industry. I just want to say thank you to MHPOP for working collaboratively with us to implement these rules that are going to be helpful for both residents and communities. Today, I wanted to highlight two parts of my submitted testimony, specifically to start off with rules 8.2 and 8.10. My reading of these rules is that they are an improper retroactive application of law. The Colorado State Constitution, Article 1, Section 11 says that no ex post facto law may be placed or no regulation be retrospective in its operation, meaning laws can't be applied backwards. And I believe I heard earlier that there's some contemplated rules to apply the House Bill 22-1287 requirements to actions that occurred before October 1st. This is not proper. Rule 8.2 seems to allow a group to use a tolling mechanism for actions before the October 1st date, post October 1st. And Rule 8.10 is more concerning because it is imposing penalties on actions that occurred before this October 1st start date, after October 1st. Just to give an example, if we issued, a community issued a 48-hour notice to entry this week, saying we're going to enter your lot on Tuesday, and then the program decides that that notice didn't include the approximate time next week, and went backwards and enforced a penalty that wasn't in existence at the time. That's not allowed. We cannot apply laws backwards. I respectfully request that Rule 8.2 and 8.10 be removed. Next, I want to highlight a topic that we've discussed already, the meter reading notice. I do like the proposal of an annual notice. I believe that this is appropriate. As John Victor previously testified, it's very difficult to do these meter readings. We need to make it practically operational. An annual notice will still give that 48 hours notice. We'll still give a time frame for residents to expect that entry and get that meter reading done. I think the date range and time range is a good proposal. And again, I would echo his comments that it should be 4 to 5 days. Parks can be large, up to 600 spots. Take some time to get the reading done. So I would respectfully request that that rule be edited to allow for that annual notice. I appreciate your time listening to my testimony and happy to answer any follow-up questions. Thank you.
Thank you, Ben, for your testimony. Christina, do you have any follow-up questions?
No.
Tori?
No.
Thank you so much, Ben.
Thank you.
Next on our list is Juanita Williams.
Okay. All right. Can you hear me?
Yes, we can hear you, Juanita.
Okay. You wanted me to introduce myself. I'm Juanita Williams from Parachute, Colorado. I own Pioneer Mobile Home Park. My intention right now, and I don't know if this is appropriate, is to make you realize that not all mobile home courts are the same. I don't believe you can cookie cutter these penalties and in rules to all of them. I've obviously missed some previous ones because I didn't know about Rule 8. And I'll just say up front, I think it's unconstitutional. And I think it's subject to challenge in court, but I don't intend to sell my mobile home park anyway. Rule 3, number 5, it just seems kind of weird. It gives tenants the impression that the rules don't really apply to them because the state will intervene. That's what I'm finding. And I've had tenants that have broken the rules consistently and ended up having to deal with them almost consistently. And she told me I was harassing her, and I thought, no, I'm not. You have had over a, I think, 3-year period, she had over 7 people come into the trailer park that were unauthorized tenants living there. I live right next door, and she's trying to tell me they don't live there. I have a very tiny mobile home park. It's only 11 spaces. I live in space 11. My daughter lives in space 4. She doesn't pay me rent. She's going to inherit it. It's very hard for a single woman in this area to make a living wage. We try very hard to keep the rent affordable. Currently, it's in the mid $400 a month range. When we bought the park, it was pretty run down and trashy. Raw sewage was under space 3. We repaired water lines and sewer lines within the first few months. We repair at the first sign of an issue. The town of Parachute has not made requirements such as yours regarding infrastructure, and they're our governing body. Some previous owners put the water and sewer under the houses rather than the streets. So every prayer is a mess, but if this is what people are living in, and we keep it clean. We have a contract with Roto-Rooter to come out quarterly to keep the sewer lines cleaned out. We've had very little problem with the infrastructure so far. It's managing to work, but there's no way with 9 spaces that I'm going to have the money to replace all that infrastructure. And I find that really, I mean, it would just break us. That's just all the way it is. And then where are these people going to go live? And we just don't have it. Fences and permanent shed structures are basically impossible. So Rule 6.10.4 A, B, and C don't work. When there's an emergency, if I have to repair, I've got to go in. And I haven't had any tenants complain when we have to make a repair. But Rule 6.6 would be a hardship, very. And but our tenants like where we're at. We have a very good relationship with the majority of them here. I'm very picky about who I allow in for that reason. I don't want anybody in here that's going to be a troublemaker. I have had a few, but not too often. But in Rule 6.5, that either it's non-applicable or cost prohibitive unless you want me to raise my
I'm
rent.
sorry, Ms. Williams, your time is up.
Well, that's it. I mean, I'm just trying to think about the fact that some of us are just tiny. I mean, I could make a living off of this trailer park. It supplements my Social Security. That's it.
Thank you, Juanita, for your input. Christina, do you have any follow-up questions for Ms. Williams?
No.
Corey? No, thank you. Okay. Thank you, Ms. Williams. Thank you for your testimony. Next on our list is John Doe. Sorry, that's a really good one. I thought that was really odd, and it is really odd because it was just the form. And so thank you for making that very clear to everyone but me. Tony Payton.
Good afternoon, Director George and MH Pop staff and State of Colorado staff. And happy Friday to John Doe. I'm the executive director for the Rocky Mountain Home Association. We represent the industry in Colorado. I want to say thank you to the MH Pop group, to DOLA, for working with us, for considering our input, through all the communication that you've done to all of the stakeholders. I want to say thank you, and for considering everybody's position. I did submit written comments to the program for consideration, and I just would like to touch on a few of the items. I won't go into like why the annual notice is such a great idea, but it's a really great idea. Think about when you're with every rule that you're looking at, every rule that you're considering adopting, think about the unintended consequences. If a mobile home park owner has to notice their residents every single month that they're going to read their meters from the 1st to the 3rd, they may be discouraged from sub-metering. Which actually leads to a loss of water, a waste of water, in a time that water is such a critical resource. So please think about those unintended consequences for what message it sends to the owners, just with the additional administrative burdens. Also, in the rules, we're requesting that fines be a minimum. Understandably, some folks just are ignorant. They don't know about the law. They don't know about the rules, and helping to educate them first before assessing excessive fines is a big request from the industry. Also allowing communities to maximize their rule enforcement capabilities. I had a meeting not even a year ago with a community, community building full of residents that were angry because the rules were not being enforced. And so please understand, and I know that this is also something that I hope the legislature is hearing, is that things can go too far. We can be restricted too much. And what that does is it leads to unhappy residents the other way. Residents that are angry because their neighbor's site doesn't look up to the standards that the rest of the residents feel it should. So please keep that in mind. Also, an interesting thought that just came to my mind while listening to the tolling portion that Christina was sharing is there an opportunity to create a maximum tolling timeframe so that this tolling provision isn't drawn out? It's not extending the sale of a property forever and ever and ever. Thank you.
Thank you, Tony.
You bet.
Christina, any follow-up questions? Corey? No.
Oh, actually, I do have one.
Oh, Christina does have a follow-up question.
And you don't have to answer this now, but if you have thoughts on it, if you have feedback on what you think would be an appropriate time period
Okay.
for the tolling.
Thank you. I just back there, I'm like, wait a minute, maybe we should cap this somewhere, just, yeah. So thank you. You bet.
Thank you, Tom. Henry Hendrickson.
Am I here?
We can hear you.
Okay, great. My name is Henry Hendrickson. I'm with Apple Tree Mobile Home Park. It is owned by Investment Property Groups, commonly known as IPG. The concern that I have, well, I have many concerns, but one of my concerns is the 90-day right to cure on the new DOLA. Basically, what we have is a situation where giving 90 days, it looks like now it's pretty much restricted to health and safety issues. One of my main concerns is if we do have a serious health and safety concern with the mobile home lot, that 90 days is way too long. It could actually be detrimental to neighbors because of the health and safety issue, and 90 days is just way too long to go. Also, 90 days for any kind of action taken by the management regarding a health and safety issue on a lot also then subjects the neighbors who are probably good, hardworking, keep their lot clean, courteous neighbors, and they go to sell their home, and people look at their home and they see the wreck next door, and the sales, well, it's hard to do. I'm not sure exactly what kind of tools we're going to need in the future to correct that situation, but right now, as it stands, it appears like this 90-day right to cure for health and safety only has taken away our tools to help good and hardworking, courteous neighbors next door. DOLA also does not seem to make it clear on the landlord rights as far as the 90-day notice goes, and it's a right to cure. I understand it's a right to cure. What I have seen recently with this is that folks will run it up to the 90 days and they'll cure the problem. That takes us out of the picture, and that's a great thing, except in the next few days they'll revert right back to the situation that got them the 90-day notice to start with. I do appreciate you guys. I myself was a victim of a bad landlord many years ago, and I want you to know that I really do appreciate you guys trying to set forth some rules and regs on this. My other issue, let's see, I've got one more real quick. Park rules and regulations. Basically, what you guys have on that is that the park rule has to be a reasonable rule, and that's totally understandable. But now we have to actually look into the rule.
Mr. Hendrickson, your time is up.
Okay, thank you. I'll do written. Thank you very much for your time.
Thank you, Henry, for your testimony. Christina, any follow-up questions?
I'll just mention that the 90-day cure period is in state statute. So Mr. Hendrickson, you may want to reach out to your state legislators. I don't believe we proposed any rulemaking on that. So contacting your legislators might be a good next step for you.
Thank you, Christina.
Thank you.
Corey? No. Thank you for your testimony. Next up is Liz Smith.
Hi, can you hear me okay?
Yes, we can. Thank you, Liz.
Well, thank you so much for the opportunity to comment today and for all the work that's gone into the rulemaking process to date. My name is Liz Smith, and I'm a Gunnison County Commissioner, and my comments are to bring suggestions are derived from conversations I've had with the mobile home park community just outside of the city limits of Gunnison, Colorado. So just hearing how this hearing has been framed, I had some comments that may no longer apply, but the first, I think, might be able to fit under Rule 6 for management, landlord, and homeowner responsibilities. And I'd like to recommend adding a rule under this heading that offers residents a reasonable way to have a way to access documented communication in their correspondence with management and landlords. And I say this because the residents I've been working with often they are required to submit their issues, questions, or complaints to a phone number that goes straight to voicemail. So they're never actually talking to a person, and this management is out of state. They often have difficulty getting a response, even when facing significant issues such as loss of potable water, which went on for nearly 4 weeks. And there was just no correspondence in this time and no way for the residents to demonstrate or track or record that they were making complaints. So I think that email, it would be a reasonable solution. And so I would just like to offer that. And then second, State Statute 3812-105 details restrictions on assessment and collection of late fees. But there's a lack of clarity both here and in 3812-802 for tenant payment receipts as to how residents can ensure late fees are being fairly assessed when they have no option to pay rent locally. And so I guess pertaining to the documentation communication suggestion, I recommend some sort of provision for postmarked by evidence when there's no local drop-off location provided. Many of these residents have been sending in rent well before the first of the month, but it's going to an out-of-state mailbox, and they are getting charged late fees without any clarity as to when it's actually received. And then lastly, I'd just like to express appreciation and caution regarding Together Colorado's comments on 8B2, requirements for public entities to exercise the right of first refusal on behalf of park residents. They're recommending that this only take place if the housing can remain affordable, which is residents not paying over 30% of their income for housing costs or lot rent. And I'm concerned that this is going to make it to where public entities are unable to assist in these transactions, even if they are ultimately a better scenario for residents because it's providing some measure of rent stabilization or perhaps even a lower rent than they would get otherwise. So we can't control the free market, and I just wanted to put that out there. Thank you for the opportunity.
Thank you for your testimony, Liz. Christina, follow-up questions? Corey? No. Okay. Thank you, Liz, for your testimony. Samantha Pinto.
There we go. Now can you hear me?
Yes, we can hear you.
All right, thank you. Sorry, user function challenge. So first of all, I do want to say many of you have heard my name and heard my voice. So you know that I've been very forthright in my thoughts and concerns and suggestions. So I want to say thank you for not just our panel, but everybody who is and has been participating, whether they're here today or not. In my community, I know it's continued to be, as I've stated before, a real concern with the tree maintenance, because our community requires that in order to obtain residency, you have to sign that you're going to take care of the trees. So having something that clarifies to state that law supersedes rules or regulations would be an important way to make sure everybody's held accountable for doing their appropriate and fair share. The reference on, and my apologies, I don't have the actual laws about application of fees. So regardless of whether it is a fee or a fine that's contested in my community, we are again required to sign an agreement that states we are okay with the fact they're going to take all these fees out before they apply lot rent or lease cost, when in fact we don't have the opportunity to do a challenge to it because it's being applied with a discriminatory or pick and choose capricious application of rules and regulations in law. So having that made into more appropriate verbiage and law would be something I would see very beneficial for all. The annual water notice, I love that idea. First of all, having the annual notice go out to all residents once a year, and or please consider adding in the verbiage or at a lease signing. Because for myself, I signed in the middle of a year. So there were things that I didn't even know about that were supposed to have been disclosed and weren't. So if that could be added as a consideration, I would be grateful. The notifications of all communications in English and Spanish to be posted in a common place, as well as sent to all within the community, is an outstanding way all to make sure everybody has the knowledge. Whether they choose to read it or not, is another point, and I can definitely understand whoever it was that said that, some don't know the laws. But making it available to them by providing it in the languages that are most common in the manufactured home communities I keep hearing about would be an integral way at valid communication for all. And let me check my notes real quick. And accountability for when the communities are doing business as standard, and no, not all of them are challenged. I couldn't agree more with the statement by one of the first speakers that they're not all the same. And I see that, and I know that, and I respect that. Thank you.
Thank you, Samantha. Christina, do you have follow-up questions?
No.
Cory? No. Okay. Thank you, Samantha, for your testimony. So Samantha was our last person signed up for testimony. Before we move on, I would like to offer again testimony if anyone was not able to sign up. Okay, it appears that we do not have any more testimony. Therefore, the comments and testimony portion of this rulemaking hearing is now closed. I will review and consider the written comments, data, views, testimony, and arguments that were submitted to me and received by Friday, September 23rd, 2022, and any others submitted prior to 5 p.m. today, Mountain Time, September 30th. In conjunction with oral comments provided here today before rendering a decision on the adoption of the proposed rules. I have 180 days in which to adopt all or parts of the proposed rules and any amendments to them. After adoption, the rules will be forwarded to the Attorney General's office with a request for an opinion on the constitutionality and legality of the rules. I will instruct division staff to also send a copy to interested stakeholders in addition to posting them on the division website. On or before the 20th, following the adoption of the regulations, the rules and the opinion of the Attorney General will be filed with the Secretary of State for publication in the Code of Colorado Regulations. On or before the 20th day following the adoption of the rules will be filed with the Office of Legislative Legal Services as required by law. Any adopted rules become effective 20 days after publication of the adopted rules in the Colorado Register. I close the rulemaking hearing at this time. Thank you for your cooperation. Thank you.